Welcome back to Behind the Crime Scene. Today we're doing something different. We're going to walk through exactly what would happen if Dezi Freeman is found either alive or dead. This isn't speculation about where he is or whether he's guilty. This is a step-by-step breakdown of the legal process that would unfold the moment he's located. Because whether you support Freeman or think he's a cop killer, understanding the system he'll face is crucial to understanding this case. And spoiler alert, if Freeman is found alive and convicted of murdering those two police officers, he's facing something that very few Australians ever face. We're talking about Victoria's harshest possible penalty, a sentence that means he'll never see freedom again. Let's break down what happens next, from the moment of capture to the final courtroom decision. Scenario 1. Found alive. Let's start with the scenario police are planning for. Freeman is found alive. Maybe he's caught in a raid on a property where someone's been helping him. Maybe he surrenders after months in the bush. Maybe he's spotted and surrounded. However it happens, let's walk through what comes next. The moment of capture. The first thing you need to understand is that if Freeman is found, this won't be your standard arrest. This will be a high-risk tactical operation involving heavily armed police, probably the Special Operations Group, possibly Defence Force support. Freeman is wanted for murdering two police officers. He's considered armed and extremely dangerous. Police aren't going to walk up and tap him on the shoulder. If he surrenders peacefully, he'll be taken into custody immediately. He'll be searched, handcuffed, and secured. If he resists or tries to flee, police are authorised to use whatever force is necessary to apprehend him, including lethal force if he presents an immediate threat. Let's be blunt about this. There's a very real possibility that Freeman won't be taken alive. If he's armed and makes any move that police interpret as threatening, they will shoot. And given what he's wanted for, no one's going to second-guess that decision. But let's assume for this scenario that he's captured alive. What happens next? Initial processing and charges. Freeman will be transported under heavy guard to a secure police facility, likely in Melbourne. He won't be going to a local station in Porepunkah. This will be a major operation with multiple vehicles, armed escorts, and probably a helicopter overhead. At the station, he'll be formally arrested and charged. The charges will likely include 2 counts of murder, 1 for each officer, 1 count of attempted murder or intentionally causing serious injury for the wounded officer, weapons offences, possibly additional charges related to his time as a fugitive. He'll be read his rights, though at this point those rights are basically meaningless. He has the right to remain silent, and if he's smart, that's exactly what he'll do. He has the right to a lawyer, and he'll definitely need one. Police will conduct a formal interview. Freeman will almost certainly decline to answer questions. That's standard practice and exactly what any lawyer would advise. Within 24 hours of arrest, Freeman must be brought before a magistrate. This won't be a trial. This is just the first step in what will be a very long legal process. At this filing hearing, Freeman will be formally told of the charges against him. The magistrate will address the immediate question, will Freeman be remanded in custody or will he be granted bail? Let me save you the suspense. There is absolutely zero chance Dezi Freeman gets bail. Bail for someone charged with murdering 2 police officers after fleeing and evading capture for months, while facing charges that carry mandatory life imprisonment? Not happening. Freeman will be remanded in custody, which means he'll be held in prison throughout the entire court process. Given the nature of the charges and the publicity around the case, he'll likely be held in protective custody for his own safety. Prison culture doesn't look kindly on cop killers, and there would be genuine concerns for his safety in general population. Freeman will need a lawyer, a very good lawyer. Actually, he'll need a team of lawyers. If he can't afford private representation, he'll be provided with legal aid. Given the seriousness of the charges and the complexity of the case, this would likely be assigned to Victoria Legal Aid's most experienced criminal defence attorneys. But here's the thing, even the best lawyer in Australia faces an uphill battle with this case. Freeman fled the scene. He evaded police for months. There were multiple witnesses to the shooting and even footage that would be released to the court. The evidence of what happened is going to be overwhelming. The lawyer's job will be to build the best possible defence given the circumstances, to ensure proper procedure is followed and to look for any possible mitigating factors that might influence sentencing. Murder charges in Victoria don't go straight to trial. First, there's a committal hearing in the magistrate's court. A committal hearing is basically a test of the prosecution's evidence. The magistrate reviews the evidence and decides if there's enough to justify a trial in a higher court. For a case like Freeman's, with multiple witnesses and likely physical evidence, this is pretty much a formality. The magistrate will commit Freeman for trial. During this process, Freeman's lawyers will get their first real look at the prosecution's evidence. This is called the hand-up brief. It includes witness statements from the surviving officers, forensic evidence from the scene, ballistics reports showing which guns fired, which shots, autopsy reports for the two deceased officers, any video or audio evidence, Freeman's own statements, if he made any. The results of that acoustic testing we've been talking about, this is where Freeman's lawyers will start to understand exactly what they're dealing with. And if the evidence is as strong as it appears, this is where they'll start having serious conversations with Freeman about pleading guilty. Once committed for trial, Freeman's case moves to the Supreme Court of Victoria's Criminal Division. Murder cases in Victoria are handled by the Supreme Court, not the County Court. This is where things get real. The Supreme Court has the authority to impose life sentences. The judges here deal with the most serious crimes Victoria has to offer. Freeman will be formally indicted, which means the Office of Public Prosecutions will prepare a document that sets out the exact charges he faces. At this point, Freeman has a decision to make: plead guilty or plead not guilty. If Freeman pleads guilty, there's no trial. Instead, there's a plea hearing where the judge decides on sentencing. Why would Freeman plead guilty? 3 reasons. First, the evidence might be so overwhelming that fighting it is pointless. Going to trial when you're clearly guilty just wastes everyone's time and makes you look worse. Second, pleading guilty early shows remorse and acceptance of responsibility. Courts give what's called a discount for early guilty pleas, usually up to 25% off the sentence. Now, in Freeman's case, that might not mean much if he's facing life without parole, but it can affect things like how he's classified in prison and where he serves his sentence. Third, a trial means the families of the victims have to sit through weeks of hearing about how their loved ones died. Some defendants plead guilty to spare the families that trauma, but here's the brutal reality for Freeman. Even if he pleads guilty, shows genuine remorse, and does everything his lawyers tell him to do, it probably won't matter much. The sentencing for murdering police officers in Victoria is harsh, and it's designed to be. If Freeman pleads not guilty, we go to trial. A murder trial in the Supreme Court is a major production. It will likely take several weeks, possibly months. There will be a judge and a jury of 12 Victorians who will decide Freeman's fate. The prosecution's case will be presented first. They'll call witnesses, the surviving police officers who were there, forensic experts, ballistics experts, medical examiners, possibly Freeman's wife or other family members, anyone who saw or heard anything relevant. Each witness will be cross-examined by Freeman's defense team. This is their chance to challenge the evidence, to create doubt, to find inconsistencies. Then the defense presents their case. Now, Freeman has the right not to testify. If he does testify, he can be cross-examined by the prosecution, and that's extremely risky. Most defendants in murder trials don't take the stand. The defense might argue self-defense, though this seems unlikely given the circumstances, that Freeman didn't intend to kill, only to defend his property, that the shooting was accidental, or in the heat of the moment, the police used excessive force or violated procedure, mental impairment, or diminished responsibility. But here's the problem. Freeman fled the scene and evaded police for months. That doesn't look like someone who acted in legitimate self-defense. That looks like someone who knew they'd done something seriously wrong. The jury will hear closing arguments from both sides, receive instructions from the judge about the law, and then deliberate. For a guilty verdict, all 12 jurors must agree. If even one juror has reasonable doubt, it's a hung jury and there might be a retrial. But let's be realistic. If this case goes to trial, Freeman is almost certainly getting convicted. The question isn't whether he'll be found guilty. The question is what sentence he'll receive. This is where we need to talk about something most Australians don't understand: the penalty for murdering police officers. In Victoria, murder carries a maximum penalty of life imprisonment. For most murders, judges have discretion in sentencing. They consider factors like the defendant's background, whether they showed remorse, whether there were mitigating circumstances. The standard non-parole period for murder in Victoria is 20 years. That means even if you're sentenced to life, you might be eligible for parole after 20 years if the judge doesn't set a higher non-parole period. But Freeman isn't facing a standard murder charge. He's facing charges for murdering police officers who were executing their duties. And in Victoria, while there isn't a mandatory minimum for this specific circumstance like there is in New South Wales, judges treat the murder of police officers as one of the most serious forms of murder possible. When you murder a police officer in the course of their duties, you're not just killing a person. You're attacking the entire system of law and order. You're showing contempt for society's rules. You're making every police officer in the state less safe because you've demonstrated a willingness to kill to avoid consequences. Courts take this very seriously. Freeman would likely face a life sentence with a very long non-parole period, possibly 30 years or more. In extreme cases, the judge might refuse to set a non-parole period at all, which means life without any possibility of parole ever. Let me be clear about what that means. Freeman is 56 years old. Even if he gets a 30-year non-parole period, he'd be 86 before he could even apply for parole. And there's no guarantee he'd get it. If the judge imposes life without parole, Freeman dies in prison. Period. No exceptions, no parole hearings, no getting out early for good behaviour. He serves every single day until he dies of old age or illness. That's the reality he's facing. Factors that could influence sentencing. Even in the worst cases, there are factors that might influence the judge's decision, mitigating factors that could help Freeman. If he pleads guilty early, if he shows genuine remorse, if he has no prior history of violence, I don't know his full record. If there were provocative circumstances, though this seems unlikely, if he has serious mental health, issues that affected his actions, if he cooperates with authorities and explains what happened, aggravating factors that will hurt Freeman. He killed 2 officers, not 1. He wounded a 3rd officer. He fled the scene and evaded capture for months. Officers were executing a lawful warrant. He showed no remorse by running. The crime was particularly violent. The impact on the families and the wider police community. The prosecution will present victim impact statements from the families of Neil Thompson and Vadim Dewart-Hotat. These will be devastating. The judge will hear directly from wives, children, parents, and colleagues about how these deaths have destroyed families and traumatized an entire police force. Freeman's lawyers might present character references, evidence of his good conduct in other areas of his life, or mental health reports. But honestly, against the weight of murdering 2 police officers, these factors carry limited weight. Life in prison. Let's talk about what life imprisonment actually means in practical terms. Freeman would be sent to one of Victoria's maximum security prisons, probably Port Phillip Prison or Barwon Prison. Given the nature of his crimes, he'd almost certainly start in the maximum security unit. His days would be highly regimented. Wake at 6 a.m, meals at set times, limited recreation time, restricted access to programs and activities, constant supervision. As a convicted cop killer, Freeman would be at high risk from other prisoners. Prison culture has a hierarchy, and cop killers are at the bottom. He'd likely spend significant time in protective custody, which means even more isolation and restrictions. If he's sentenced to life without parole, he has no incentive to behave well. There's no parole hearing to work toward, no sentence reduction for good behaviour. Some prisoners in this situation give up entirely. Others cause problems because they have nothing to lose. If he does have a parole eligibility date 30 or more years away, he'd need to maintain good behaviour, complete programs, show rehabilitation, and convince a parole board decades from now that he's no longer a threat to society. The odds of that actually happening? Extremely low. Now let's talk about the other possibility. Freeman is found dead in the bush. This changes everything, but not in the way you might think. If Freeman's body is found, there won't be a criminal trial. Dead people can't be tried for crimes, but there will be a coronial inquest. A coroner's job is to investigate the circumstances of a death and make findings about how the person died. In Freeman's case, the Coroner's Court of Victoria would need to determine, when did Freeman die? What was the cause of death? Where exactly was his body found? How long had he been dead? The inquest would also examine the deaths of the 2 police officers. This is where all the evidence we've been talking about would come out publicly. The ballistics results showing which guns fired, which shots, the tactical approach used by police, whether proper procedures were followed, the acoustic testing results. Whether friendly fire played any role, witnesses would testify. The surviving officers would have to explain what happened. Freeman's wife might testify about his state of mind. Forensic experts would present their findings. The coroner would make formal findings but wouldn't assign criminal blame. However, the coroner could make recommendations, changes to police procedures for serving warrants on high-risk individuals, better tactical planning requirements, training improvements, policy changes. This is important because if the coroner finds that police procedures were flawed or that friendly fire was involved, it could have massive implications for VicPol, even though it wouldn't result in criminal charges. The incomplete justice. For the families of Neil Thompson and Vadim Dewat Hotat, Freeman being found dead would be deeply unsatisfying. There's no trial, no verdict, no judge telling Freeman he'll spend the rest of his life in prison for what he did, no victim impact statements read in court, no formal finding of guilt, just a coronial inquest that determines Freeman died in the bush, probably shortly after fleeing the scene, and that he was responsible for the officers' deaths. It's closure of a sort, but not the kind of closure that comes from a courtroom conviction and a life sentence being handed down. If Freeman is found dead, we might never get answers to crucial questions. Did he intend to kill those officers? Or was it a panicked reaction? Did he have help in the aftermath? Where was he during the 80-plus days before he died? Did he feel remorse? What was his plan? Hide forever or eventually surrender? Those answers die with him. The wider implications, regardless of whether Freeman is found alive or dead, this case has implications beyond just one man's fate. 4 police procedures. Victoria Police will conduct internal reviews of how this warrant was executed. Questions will be asked. Should SOG have been deployed given Freeman's history? Was the tactical approach appropriate? Were there warning signs that were missed? What can be done differently next time? If Freeman is captured alive and goes to trial, his defense team will scrutinize every aspect of the police operation. Any procedural failures or tactical mistakes will be exposed in court. For sovereign citizen movements, the sovereign citizen movement in Australia will be watching this case closely. If Freeman becomes a martyr figure for people who believe the government is tyrannical, it could inspire others. Alternatively, if Freeman dies in the bush or receives life without parole, it might serve as a warning. This is what happens when you take up arms against police. This is the price of violent resistance. This case will reignite debates about gun ownership in Australia, particularly in rural areas. Freeman had firearms at his property. Were they legal? How did he obtain them? Should there be stricter controls? These questions will be asked in Parliament, in the media, and in the community. If Dezi Freeman is found alive, he faces the full weight of Victoria's criminal justice system. Arrest, charges, remand in custody, committal hearing, Supreme Court trial, or guilty plea, and almost certainly a life sentence with decades before any possibility of parole, if parole is even an option. If he's found dead, there will be a coronial inquest that examines not just his death, but the circumstances of the officers' deaths. The truth will come out, but without the satisfaction of a criminal conviction. Either way, the families of Neil Thompson and Vadim Dewat Hotat face a long road ahead. Court processes in Australia move slowly. If there's a trial, it could be a year or more before it concludes. That's a year of reliving the worst day of their lives, of hearing evidence, of waiting for justice. For Freeman, if he's alive out there in the bush, he has a choice to make. Surrender and face the legal process, or keep running until he's caught or dies trying. The clock is ticking. The $1 million reward stands. Every day he's out there, more tips come in, more searches are conducted, more resources are deployed. Eventually, one way or another, this manhunt ends. And when it does, we'll finally get the answers to all the questions we've been asking since August 26th, 2025. Thanks for watching Behind the Crime Scene. This was a different kind of video, more educational than speculative, but I think it's important to understand what the legal process actually looks like, rather than just guessing about it. If you found this breakdown helpful, subscribe for more detailed Australian legal analysis. And remember, whether you sympathise with Freeman's anti-government views or think he's a murderer who deserves life in prison, understanding the system is crucial to understanding the case. Stay informed, stay critical, and let's see how this unfolds.